Yes.
May please, Your Lordship. My lord, I may be permitted tomorrow to move a bail application because the mother has expired of the accused appellant. So, and there's also connected appeal.
May I please, Your Lordship? So in item number 5, Lordship, we have filed an additional affidavit. That may kindly call for Lordship. We take on the record.
Additional affidavit
Yes,
in a
Lordship.
criminal appeal.
Yes, Lordship. There is a custody certificate that we have brought before this honorable court. Deep lovely.
May it please, Your Lordship, I period for listing a fresh appeal, my lord, tomorrow or day after tomorrow. Filed on, my lord, 4 to 12, my lord. Appeal
Why-
against
why-
conviction, my lord. Tomorrow, my lord.
Day after tomorrow.
Day after. Oblige.
May it please, Your Lordship. Lordship, I beg to mention for listing one criminal appeal. It's we have filed an IA also. The matter was listed last on 39/2024.
Yes, in January you choose a date, January.
Lordship, any date in this week,
January,
January, a date may be fixed, Lordship.
you choose a date,
Lordship.
you choose.
Maybe on the 3rd of January. Oblige, Lordship.
Daily list for admission item 1.
So it's an appeal against conviction, will admit the appeal.
Lordship.
Yes, heard Ms. N. Burman, learned amicus curiae appearing for the appellant. Also heard Ms. S. Jahan, learned APP Assam representing the state. This appeal is directed against the judgment and order dated 1/3/2024 passed by the learned session judge, Bishwanath Charlie, in connection with sessions case number 362/2017, convicting the sole appellant under section 302 of the IPC and sentencing him to undergo rigorous imprisonment for life and also to pay fine of rupees 5,000 in default, to undergo simple imprisonment for 3 months. Full stop. We have perused the grounds taken in the memo of appeal, admit the appeal, call for the LCR, issue notice returnable in 4 weeks. Since Ms. Jahan has accepted notice for respondent number 1, no formal notice is required to be sent to the said respondent. Any respondent number 2, informant is.
No, my lord, it's a 302 case.
Acha. Accepted notice for respondent number 2, respondent. No formal notice is required to be sent in this case. Let the matter be listed after receipt of LCR.
Okay. Item 2.
May I please, Lordship? It's a jail appeal, Lordship.
302.
302, life imprisonment and fine. National case number 4 of 2023.
This jail appeal is directed against him. It will be of this heard Mr. SD Purkaspan, amicus curiae appearing for the appellant, also heard Ms. S. Jahan, learned APP Assam appearing for the state. This jail appeal is directed against the judgment and order dated very different. 22/2/2024 passed by the learned session judge Sonipur in connection with sessions case number 04/2020, convicting the sole appellant under section 302 of the IPC and sentencing him to undergo rigorous imprisonment for life and also to pay a fine of rupees 5,000. Baki khine 3 months simple imprisonment and rest will be same. Yes.
Item 3.
376. Oh, 376.
But Mrs. D.
May I please, Lordship? Jail appeal, Lordship.
Yes.
It's a jail appeal, Lordship.
Yes. You are appearing as amicus curiae.
Lordship, legal aid counsel.
Legal aid counsel appearing for the appellate. Also heard Ms. So-and-so learned APP Assam appearing for the state. This jail appeal is directed against the judgment and order dated. Judgment dated 20. Yes, judgment and order dated 28/2024 passed by the learned additional sessions judge Special Judge bracket POXO bracket close, comma Morigaon in connection with POXO case number 10/2019, convicting the appellant under sections
376 AB Lordship.
AB of the IPC, read with section 10 of the POXO Act, and sentencing him to inter alia undergo rigorous imprisonment for 20 years and also to pay fine of rupees 20,000, in default to undergo further rigorous imprisonment for 6 months. Full stop. We have perused the grounds. No, conviction is only under 376 AB.
376 AB
Read
Lordship.
with none 376 AB. We have perused the grounds taken in the memo of appeal, admit the appeal, call for the LCR, issue notice returnable in 4 weeks. Since Ms. Jahan has appeared and accepted notice on behalf of the state, respondent number 1. The notice has to go to the
Yes,
victim.
yes, 376 AB is included.
State respondent number 1. No formal notice is required to be sent to the said respondent. Notice be however sent to the victim stroke informant by registered post with AD. Steps be taken within a month, within a week.
Lordship.
List after receipt of LCR. And you take it a thought. List again after receipt of LCR.
May I please, Your Lordship, ma'am?
Take care of it. Yes.
Appeal against conviction, my lord. 302-149, my lord.
Heard Mr. N.K. Mahajan, learned counsel appearing for the appellants.
There are 3 appeals. 3 appeals. ma'am.
Yes, this appeal is preferred against the judgment and order of conviction dated
It পরিবার নিবে তোমার তো? এবারটা দেখেছো? ও আচ্ছা আচ্ছা।
dated
Admission.
5/10, judgment dated 5/10/2024 and order dated 7/10/2024, whereby the appellants have been convicted under section 302/34 IPC,
149, my lord.
302/149 IPC.
And other sections.
Page 92, man. The sentencing. Life for 302-149.
And inter alia sentenced to undergo rigorous imprisonment for life. No, rigorous imprisonment for life and to pay fine of rupees 20,000 each, in default to suffer simple imprisonment for 1 year for committing the offense under section 302/149 IPC. We have perused the grounds taken in the memo of appeal, admit the appeal, call for the LCR, issue notice, return in 6 weeks. Since Ms. Jahan and APP Assam has appeared and accepted notice for the state, no formal notice is required to be sent to the respondent number 1. Appellants to however take steps for service of notice upon the informant stroke respondent number 2 by registered post with AD. List this matter again after receipt of LCR.
So there's a IM.
IA, you write so and so for the applicant, so and so for the state. This IA has been filed under section
432 BNSS.
432 of the BNSS, praying for suspension of the jail sentence as well as for release of the applicants on bail. The prayer made in the IA will be considered after receipt of LCR. The state, in the
yes.
meantime, file objection, if so advised.
It is 430 man.
430
Subclause 3 man.
bracket 430 bracket 3 of the BNSS.
Obliged, ma'am. Highly obliged, ma'am.
So this is an appeal against the order of conviction. But without going into the merit of the case, your lordship give me 5 minutes only. Because this your lordship has to hear this matter. There are some matters which has been admitted, sentence has been also suspended. But for today, my lord, I think your lordship just give me 5 minutes on technical points. Whether forgetting
Take 7 minutes.
my lord, apart from the notice on the merit of the case, without going to merit of the case, relying on the order that has been passed by this court in two of the cases on the ground of half the term, now it is 1/3. 1/3 as per BNSS, which is 479, which is earlier 436A of the BNSS, which is now from 1st of July 2024. It is effective, but we all lordship relied, and there is a judgment of the apex court which says that retroactive effect can be given to those who are not only UTPA, also to a convict which your lordship has decided. In Jiten Singh case. Jiten Singh case, I brought the two judgments of this court. Now, the punishment which was given was, my lord, consecutive. Consecutive 31 years. Aggregate is 31 years, but maximum conviction under the provision of the Act is 14 years, which the sentence is of 14 years. If it is, my lord, if it is actually this 14 years, now, my lord, I have served today 6 years, 23 days, which is on record. That's why my learned friend in the morning has mentioned before the court that we have bought an IA with showing a custody certificate by the jailer saying 6 years, 23 days without remission. So if it is in be taken 1/3 because of 14, so it is, my lord, 4 years something, 8 months, which is now 6 years, 23 days. So in a Jiten Singh, two of the case which I brought before this court, your lordship said that you can file objection, but as a matter of right, that a judgment of two honorable court, my lord will kindly see. This is a division bench. My lord has passed the judgment is IA 16 of 2019. Jiten Singh. And one is Inas of Singh, my lord. Yeah. Okay. The lordship is holding which one, my lord? My lord will kindly hold Inas of Singh judgment. First, Inas of Singh by the lordship case IA criminal 600 of 222 to 2022. Lordship got it?
Yes, yes.
Kindly see, my lord, paragraph by referring page number 3/6. By referring to the statement, lordship got it?
Yes, yes.
By referring to the statement made in IA, DK Mr. So-and-so, submit there is no dispute about the fact that the applicant has served more than half of the maximum punishment awarded to him. In view of the decision of the Honorable Supreme Court, referred in case of Satyendra Kumar Antil, so-and-so, in AR, Mr. submits that since the final hearing of the appeal is likely to take some more time, the present is a fit case where the applicant deserves to be released on bail. It is also the submission of Mr. Misra that his client was earlier released on bail, but he did not violate the terms and conditions of bail. The applicant surrendered before the court after the impugned judgment was passed. Now, if your lordship looks into the last part, Mr. R.K. Dev Chaudhary of this order, R.K. Dev Chaudhary learned so-and-so appearance was submitted in his usual fairness, save and accept the sentence imposed under section 20 of UPA, read with section 120B of the IPC. Applicant already served the jail sentence in respect of his conviction of all other penal provision. Mr. Chaudhary submits that he is not denying or disputing the fact appellant has already served more than 50% of maximum sentence of 10 years awarded under section so-and-so. However, referring to section 389 of the CRP, seeks time to file objection in this IA. We have considered, now my lord, we have considered submission by so-and-so. As noticed above, there is no dispute about the fact that applicants already served more than 50% of maximum jail sentence of 10 years imprisonment. Applicant has been in jail for 5 years, 1 month and 15 days as on date. Insofar as the conviction sentence awarded under the other provision admitted position of fact, pendency of the appeal, the applicant has served the jail sentence in respect thereof. Now, your lordship has referred one judgment, which you are going to refer 2021, saying other than life sentence, the border parameter of 50% actual sentence undergone can be a basis for grant of bail. Now, if your lordship kindly go into other page number 5-6, page number 5-6, insofar as last paragraph, last to last three, insofar as fourth line from the bottom, insofar as the objection raised by so-and-so file objection, what is to be noted here, similar bail application filed with the other applicant, Jiten Singh, so-and-so, on the same grounds as urged in this IA, already filed objection. Mr. Chaudhary has also not disputed. Grounds taken in objection filed in so and so, seeking suspension sentence under section 300 will be the same in the, if that be the so, having regard to the facts and circumstances of the case, also the fact that this court is closing down for long vacation a day, inclined to defer the consideration so and so, allowed to similar for reason discussed above and having regard to facts and circumstances, we are the view, succeed in making out a strong prima facie case to allow him to go on bail. We therefore direct the applicant so and to release on bail, punishment of so and so, so and so.
It is aggregate punishment to put.
So now, my lord, here,
Aggregate was.
here, my lord, the aggregate punishment in this case was 18 years. My lord, we found out, my learned
So
friends,
just a minute. When was the judgment conviction passed?
my lord, in the case of the present case, which your lordship holding,
Yes, yes.
22nd of.
22nd,
It was found in.
my your lordship
page
kindly see
910.
page 910,
Volume.
volume 5, my lord, volume 5, volume 4,
What is
my
the
lord,
date of the judgment?
22/7,
22/7.
7/2024. 22/7, 2024.
Okay, so appeal has been admitted.
No, for the first time.
First time it has come.
First time it has come. Only what I was saying that I was showing the judgment.
Hmm.
So whether he is entitled to get bail. So in IA, we file a separate IA. We are saying that based on the same, which your lordship considered on the very first day, because as a matter of right, because
No,
on the,
that was not very first day.
no, this case,
No,
man,
no,
Jiten Singh,
the respondents had filed objection
No,
in
no.
one of the connected cases.
no, no,
Taking
my
the same
lord,
ground.
no. Other co-accused, so they have filed, my lord, other co-accused in our case also, that they have filed, they have filed. They have filed in others.
So you are saying state should not be granted time
No,
to file?
absolutely, they will be granted. But what I was showing before this court, that whether today, I don't know, my lord, it's up to the
No,
court.
it's a point, Mr.
That's why.
Das, we appreciate.
Yes.
because, We'll have to look into these matters.
Only for a moment, if it's not inconvenient to your lordship, my lord, volume 4 kindly be looked into it. This one again.
You are appearing.
My lord, yes, I am appearing for the statement.
Yes.
Now, my lord, my right may not be curtailed, my lord. The institute has given me the right to file an objection in this case. So let us
No,
admit
that
the
is-
How
appeal.
much time do you want? Yeah, it can't be long.
My lord, yes, anytime may be given, my lord, after 1 week, 2 weeks, 3 weeks, whatever. I am ready to file, my lord.
We'll have to give
But
him.
my opportunity should not be
No,
curtailed.
that's why I am not saying that your lordship definitely as to why I will say. What I am showing before this court.
Hmm.
No, that's what I am saying.
7th January.
My lord, there's no problem, my lord, that's absolute, once your lordship, just troubling your lordship. Page chapter, there's volume 4, my lord, if your lordship looks into it,
Yes.
just for a moment, my lord.
Yes.
Even their filing of the objection will not change the law.
Because your lordship has observed, has found.
No, certainly.
After reading, no, your lordship is right. After this going through your lordship's both the order, that filing an objection, they have got the rights to file. That will not change the particular, the admitted position that 1/3 and it is completed. I told my learned friend that you have to file an application showing custody certificate. That to what period I am there in the custody. 6 or 23 days. Now the position of law before the BNSS came into effect from 1st of July 2024, under 436A, it was half term.
Correct.
But once your lordship relied, once it is 1/3 and it is to be given benefit to those, not only UTP also, which has been discussed by learned Supreme Court in one of the matter, to convict also. So your lordship held that particular in the judgment. So your lordship kindly see 1197 page. 1197.
You could have filed it earlier, then we could have taken it before the vacation.
Yes, I know.
11,
1197.
but we have to give him the state time to file objection, reasonable time.
No, I just want to show the position, my lord. My lord, 1197, if your
Yes.
lordship kindly take. My lord, kindly see the name of the accused, lordship got it,
Mhm.
and see the date of arrest 17/8/2017 on
Yes.
the top. And third column, that will be really fourth column, date of release of accused 28/3/2020.
You're referring to 11?
Page 1197.
IA
IA.
volume 4.
IA volume 4. IA volume 4. IA volume. ऐसे नहीं है. It's more than 7 minutes, my lord. Now time
Flexibility
is very difficult. I have seen in the Apex Court also. 10 minutes, we are not beyond 10 minutes. 2 minutes for interview. See 1197. A lordship, I think, Honorable Justice.
Yes.
Now, lordship got it.
Yes.
I think this time it's
We will admit the appeal, first of
Yes,
all.
yes.
Heard Mr. D. Das, Learned Senior Counsel, assisted by
by Mr. Yes, does.
Mr. S. Das, Learned Counsel for the appellant. Also heard Mr. M. Phukan, Learned PP Assam, appearing for the state, respondent number 1. This appeal is directed against the judgment and order dated 29/7/2024, passed by the Learned Special Judge, Assam, in special case number 05/2021. Arising out of Bhangagarh PS case number 159/2017, registered under section 120B of the 420/468 of the IPC, read with sections 7/13 bracket numerical 1 bracket close bracket small a bracket close bracket small d bracket close bracket Roman 3 bracket close /13 bracket numerical 2 of the Prevention of Corruption Act 1988, convicting and sentencing the appellant to undergo rigorous imprisonment.
Yes.
Is it? Rigorous imprisonment for 14 years in total. Full stop. We have perused the grounds taken in the memo of appeal, admit the appeal, call for the LCR, issue notice returnable in 6 weeks, since Mr. Phukan, Learned APP Assam, has appeared and accepted notice for respondent number 1. No formal notice is required to be sent to the state respondent number 1. Full stop. Appellant to take steps for service of notice upon respondent number 2 by registered post with AD within a week from today. In the IA 1230 of 2024, likho. Heard Mr. D. Das, Learned Senior Counsel, assisted by so-and-so, Learned Counsel for the applicant. Also heard Mr. M. Phukan, Learned APP Assam, Learned PP Assam, appearing for the state respondent number 1. This IA has been filed under the application starts in which page?
It starts
Application first page.
volume 1.
This IA has been filed. Where is IA first volume? (430) (3) of the BNS, with a prayer to 430 (1) of the BNS, with a prayer to suspend the jail sentence of the applicant and for releasing him on bail. By referring to section 479 of the BNSS, Mr. Das, Learned Senior Counsel for the applicant, submits that his client has been in jail for more than
6 years,
6 years, and
22 days.
therefore has served more than 1/3 of the jail sentence, maximum jail sentence. Therefore, in view of the mandate of section 479 of the BNSS, the applicant cannot be continued in jail custody more than 1/3 of the total period of sentence imposed upon him by the learned court below. Full stop. On such ground, Mr. Das has prayed for release of the applicant on bail without giving any further opportunity
Yes.
to the state to oppose the prayer. Full stop. Mr. M. Phukan, Learned PP Assam, on the other hand, submits that submitting objection opposing the bail prayer is a right of the state, and therefore he be granted at least 3 weeks' time to file objection. Taking note of the submission of learned counsel for both the sides, the state is granted time till 6th of January 2025 to file objection by serving advance copy upon the learned counsel for the applicant. Let this matter be, we'll have it on 8th because 7th it may not, 8th of, let this matter be listed again on 8th of January 2025 as a fixed item.
I'm deeply obliged. I'm deeply obliged.
Much obliged, Your Lordship.
My lord allows, since he is here,
Order
Mr. Mahathukon is here, lordship, he can apprise of the issue on filing of appeals by the state.
My lord,
Yes, Mr. Fukan,
my lord,
He has collected something.
my lord, yes, my learned friend, my
the
lord,
matter is fixed tomorrow.
tomorrow, yes, my learned friend, my lord says, my lord, is there any SOP or guidelines is there?
Please come tomorrow when the matter is,
My lord,
tell us what you're doing.
First hearing.
yes, I have collected the SOP, my lord, it is there, my lord.
Then why strangely is no appeal has been filed?
I can take your.
Yes. Eyewitness account is there, same
My lord.
evidence. One has been convicted, others have been,
My lord, yes,
we are going to acquit the other because that is the law. But we'll put the blame, highlight it straight away on the state. Complete,
but state has, my lord, there is an SOP, my lord, guidelines is there, there is a, my lord, district level committee is there, my lord, after acquittal, the, my lord, any of the judgment passed by the any court, my lord, there is a district level committee, my lord, who
that's all
prepares.
right. You have your committees. These are
Right.
your internal matter.
My lord,
We want to know when there are eyewitness testimony against more than one accused. One has been convicted, others have been acquitted.
my lord.
Do you agree with that view?
No,
You
my
tell
lord,
us that.
of course not, my lord.
Then why no appeal has been preferred against that?
My lord, yes.
We are now compelled to acquit the other, all probability we have to acquit the other accused, despite there being eyewitness account.
My lord,
And these are matters the public should know.
Okay.
We'll make sure that the people knows this is how the state is functioning. Because it is your responsibility.
my lord, yes.
Somebody has been hacked to that. There are eyewitnesses account. We are sad that the judicial officer did this kind of a thing. I don't know. We don't know why he did it. But even the state has remained silent.
Lord, sir.
No effort made to even trace out the absconding. What is happening? Please look into it.
My
We'll request you to be present tomorrow and address the court.
My lord, my lord,
These matters will go out.
my lord.
We will use media now.
Hmm.
We have taken a lot of onslaught of media. Now we are going to use it. As judges, we'll use media. Let the people know what actually happens. Why should only one-sided version go out?
Lord, sir.
Why should one-sided version? The public is thinking that the court is acquitting, court is delaying matters, and only the suitable things are going out in the media. Let everything go. Let the whole version go. We are having live streaming now.
Lord, sir.
Selectively cut paste things are being sent in the media. Media is not interested in these things. Why is the media not interested to know that in a matter where there are eyewitness account implicating 4 accused persons, one is convicted, 3 others are acquitted. The state remains silent. Why is the media not interested to know that the law is that if the evidence is same, if you are acquitting some of the accused, you have to acquit the others. Why these things should not be known to the people? Unfortunately, the media doesn't seem to be interested in this, the social media or whatever.
Absolutely.
We also have to be careful about these things. One-sided versions are going out. The court is not doing this, court is not doing that. There is delay, acquittal. We are not accusing anyone. We are only
Right.
saying that the reality must come out.
Lord, sir. Correct.
Do you support this?
No, well, how can I support?
Or you tell us that no, this is not the position. There is something the court has missed out. That you can tell us. Something was there which was not brought to the notice, then it's okay.
My lord.
But on the hearing, we found that there are eyewitnesses account. The injured eyewitness has given testimony against all 4 accused persons, and we'll definitely take up this matter in the administrative side against the judicial officer also.
My lord, yes.
Nobody will be spared. Nobody.
Correct, my lord. It's very surprising. If there is direct eyewitness, my lord, how they can admit, my lord?
No, that's why, Mr. Pukon, we are requesting you, please spend a little time,
My lord, yes, sir.
go through it.
My lord.
Is there anything we have missed? If we have missed something, then
Lord,
we'll
sir. Lord, sir.
reorganize. But if this is what is the reality, this is shocking.
My lord, yes.
I'm coming up against judgments where death sentence has been awarded on the basis of Confession made in police custody? What is
Right.
this? Of course, state is doing. Of late, we know that the state of Assam has taken many significant steps.
My lord.
But despite that, these are some areas where these are going unnoticed. So the
Right.
first thing is to raise a flag. Second thing is the people have a right to know everything, not only
Of
one
course,
version. All the versions should come out in public domain. If there is social media, if there is live streaming, then let everything be out.
Hmm.
Let the people take a decision what is happening.
Correct. Your lord.
We are not otherwise directly accountable, but we would like information to free flow to people on everything,
My lord.
not only on one aspect or other, everything. That's why this effort. So please be
My lord.
present tomorrow and feel free to make your submissions.
My lord, sure.
You may disagree, you may have another version to prove. We are not averse to appreciating those arguments. Okay.
Lordship.
The SP, why the police has not taken any step
My lord, of
to-
course.
apprehend the where has he gone? He has disappeared. This is a security, internal security issue.
Hmm.
If you have crossed the border and he is traceless, then also it's a security, internal security issue. That means people can commit crime here and cross the border and disappear. Then what is the use of having all this border police fencing and all these paraphernalias? So we need to know what is happening.
My
That's
lord.
the point. So that we pass our orders without causing any inconvenience to any of the authorities. If somebody is slipping over his duties and responsibility, then we'll take them to task. That's the whole idea. Yes. Next matter, please.
Much obliged.
These two orders in my chamber.
May I begin, Lordship, my lord? This is 30 to 34.
Yes.
30 to 34, my lord.
30234.
34, my lord. Three appellants, my lord.
Okay.
My lord, page 14, my lord, there are two dates of judgment, my lord. That is when the cost life mentioned two dates of judgment, my lord.
Two?
In page 14, my lord,
Yes.
second last block, my lord.
Why there are two dates?
I don't, that is how it is written. So in the cost life, done the same thing, my lord.
I've seen other. So is there an order of sentencing which Jahan, what is the reason why there are two dates given?
Sentencing was separately given.
So is it the date of the judgment is 2410 and sentencing order is 1611?
1611. Even under the CRPC, there should be a time between judgment and the sentencing.
Yes, ma'am.
So they have taken a long time, but.
Page 56,
1611.
but my lord, the continuation, it only 1:16:11 is there, my lord. Page 56, my lord, the judgment ends, my lord.
Page 56.
Given under my hand and seal on 16th November 2024, my lord.
Resolution 56. This is the judgment.
There is no, my lord, 2410, my lord. In the online also, I checked, my lord, only 1611 is there, my lord, at e-courts.
Sentencing is not given.
A sentencing was so was khali atai or data second.
Order.
All right. I heard Mr. N.K. Mahajan, learned counsel for the appellant, also heard Ms. S. Jahan, learned APP Assam appearing for the state. This appeal. Is it an application? You've written application under section 415?
Yeah, application, so it should be appeal, my lord. 415(2), my lord, appeal.
Is appeal filed under section 415 bracket 2 bracket close of the Bharatiya Nagarik Suraksha Sanhita, 2023 bracket BNSS is directed against the judgment and order dated 16/11/2024 passed by the learned additional sessions judge bracket FTC bracket close, Rangia, Kamrup in sessions case number 101/2010, convicting the three appellants under section 302/34 of the IPC and sentencing them, each of them, to undergo rigorous imprisonment for life and also to pay fine of rupees 5,000, in default of payment, to undergo simple imprisonment for 1 month. We have perused the grounds taken in the memo of appeal. Admit the appeal, call for the LCR, issue notice returnable in 6 weeks. Since Ms. S. Jahan, learned APP Assam, has appeared and accepted notice on behalf of the state stroke respondent number 1, no formal notice is required to be sent to the said respondent. Appellants to take steps for service of notice upon the respondent number 2 stroke informant by registered post with AD within a week from today. Full stop. While going through the memo of appeal, we have noticed that 2 dates have been mentioned as the date of the judgment, namely 24
Page 14, madam.
24/10/2024 within courts and 16/11/2024 within courts. Full stop. However, on a prima facie examination of the materials on record, we did not find any relevance of 24/10/2024 with the judgment. Full stop. A judgment rendered by the learned court below cannot have 2 dates, as the same would create unnecessary confusion in the long run. Under the circumstance, we direct the registered judicial to inquire into the matter and put up a note explaining the position. Full stop. Is there a IA?
There's I.
IA so-and-so, IA is filed under
430.
430 bracket 1 of
two.
the B.
Three.
Two.
432.
432 bracket 2 of the BNSS. So-and-so delay. The prayer made in the IA shall be considered after receipt of LCR. The state may in the meantime file objection if so advised.
Obliged, highly obliged.
Seven.
You served a copy long back. Then you serve it.
When?
We need it, 1 week we'll do, in the meantime, vacation will come.
Immediately after vacation loss.
Okay, heard Mr. J. Kolika, learned counsel for the applicant, also heard Ms. B. Bhuya, learned HPP Assam appearing for the state. Mr. A. Atal, learned legal aid counsel is present on behalf of the respondent number 2. On the request of Ms. Bhuya, this matter is directed to be listed again after 10 days so as to give one more opportunity to the state to file objection. List accordingly.
Loss. Obliged.
Item 9. Thank you. Please.
May I please your lordship? The appeal is against the POXO Act, lordship. Convicted for 20 years. Accordingly, we have taken the steps upon the respondent number.
The conviction is under 302.
Lordship. Life.
All right. So what do you want to do today? You want to argue this case? You want to,
Not
What?
today, lordship.
not today.
Not today, lordship. It just came up for order, lordship. That is why I am not thoroughly prepared.
You have a bail application
Lordship.
and you don't want to argue it today.
Soon after vacation, lordship.
Not today. Mr. P. Das, learned counsel for the applicant stroke appellant submits that the state has already filed objection in this case. Therefore, the IA be taken up for consideration immediately on reopening of the winter vacations. First of Ms. B. Bhuya, learned APP Assam, has no objection to the said prayer. In view of the above, register to list this matter again after reopening of the winter vacation.
Lord. Obliged, lordship. Deeply obliged.
Item 11.
Wait, prisoner. My lord, as per office note, my lord, service on respondent number 2 is complete. Flag SR1 may be seen.
But none has appeared. No one has appeared. The conviction is under which section?
302, my lord.
302, it's all right. Service is not mandatory.
May not be.
also.
My lord.
So now LCR has come. So
My lord,
let-
state already filed objection, my lord. My bail petition, my lord, that may
Yes.
be taken into.
Today,
Not today, my lord, because the service is complete today. So thereafter, my lord. After
then
vacation,
after vacation.
in the January first week, my lord.
All right. First week only 1 day is there. Second week.
Second week, my lord.
Yes. Heard Mr. M. S. Sheikh, Learning Council for the appellants. Also heard Ms. B. Buyal, APP Assam appearing for the state. Peruse the office note which goes to show that service of notice is complete upon respondent number 2. Mr. Sheikh submits that since this matter is ready as regards service and the state of Assam has also filed objection in the connected IA, copy whereof has been received by him, the IA be listed for orders again in the second week of January 2025. Prayer allowed, office to list the matter.
My lord, regarding respondent number 2, my lord, case will proceed ex parte.
That the law will take its own. There is no
My
need
lord.
to.
Another thing is this, my lord. In earlier occasion, my lord, earlier appeals, your lordship noticed the 2 dates. One is sentence, another is judgment. This trend started from 2023 in later part, my lord. Earlier also, I did not see like this.
No, that's another thing. There
My
can
lord,
be a
that-
judgment and an order, but here in this case,
Judgment, no, sentence, my lord. Sentence is in another date. Supposing in my case, my lord, judgment 18/6/2024. And order of conviction is 26/2024.
we are inquiring.
My lord, so that should be inquired into, my lord, by the registry. Oblige, your lordship. Second.
Lordship states, service is complete here. OC has given one
This
report.
IA is for what? Bail.
Bail, my lord.
Acha. State has filed objection.
It's a file objection.
All right.
Lordship, informant has already been expired. IO has submitted a report, my lord, along with the death certificate.
POXO Act is involved.
So is
These are new cases.
New, not new cases, item number 15, 2022. And they are in charge of them for about
Have
2
we
years.
heard already?
No,
this
no,
matter?
no, not hardly. Not hardly. They are in jail, lordship, for about 2 years, 3 months, lordship.
So it's better you do it in the new year because now tomorrow and day after we have some previous matters. So judgment is not coming and we will also not conclude the hearing. If we don't conclude the hearing, unless the bench is available, this will be a meaningless exercise. What do you want to do? You decide.
I leave up to your lordship. Let
We
do
have,
in
we
the
have
new
some
year.
parted matters fixed, is it not? Tomorrow?
Lordship, tomorrow there, are- yes, tomorrow there's part.
But the cases we have heard, we want to give judgment first. So if you argue also, we'll keep it for further hearing after vacation. And if this bench is not available, you are stuck up.
12 witnesses are there, 12 PWs.
302,
302.
eyewitness.
Eyewitness is there, but story not corroborated with the FIR, lordship.
Second week of January. What about your matter?
Item 16, lordship. One person is in custody, circumstantial evidence, lordship.
And I have
Why
seen
that?
half of the case, half of that case.
Yeah, after tomorrow.
3 witnesses I have seen, not beyond that. Lordship will take it up on January.
Day after tomorrow.
Oh, day after
Day
tomorrow.
after tomorrow, we'll fix a date in January. That's the only one. Because it will not be possible to deliver. We will not keep any matter parted.
Gotcha.
Because there is no clarity on whether New Year this bench will be available or not. Or Thursday, you put it on Thursday.
How like?
Yes.
Of London.